Good morning, good afternoon. Welcome everyone to the latest in our Eventcast series. My name is Greg Menken, Executive Director of the Adam Smith Society, and I want to welcome everyone for joining us today, especially during these ongoing and challenging times. Whether we are online or in person, the mission of the Adam Smith Society to promote discussion around the broad societal benefits of capitalism continues. To learn more about SmithSoc, please visit us online at adamsmithsociety.com. Joining us today to talk about his upcoming book, The Unelected, and How to Tame the Administrative State is James Copeland. He'll give us a 15 to 20-minute briefing based on his upcoming book, followed by audience Q&A. Please submit your questions through your control panel on the right of your screen. Please state your name and SmithSoc chapter affiliation to ask a question. Please note, we are recording. Now I'd like to introduce our speaker. James Copeland is a senior fellow and director of legal policy at the Manhattan Institute. His forthcoming book, The Unelected, How an Unaccountable Elite is Governing America, will be released on September 8th. I encourage everyone to check it out, order it online. It's really going to be a fascinating read, and we're delighted to get a little sneak peek of it today. He has testified before Congress, state and local legislatures around the country. He appears regularly across media channels, print, online, television, you name it. Prior to the Manhattan Institute, like many of our members, he was a management consultant at McKinsey, and he holds his JD and MBA from Yale, so he is truly one of our SmithSoc family. Jim, thanks so much for joining us today. The screen is yours.
Thanks so much, Greg, and thanks to everyone out there. I am a member of the Adam Smith family. When I was in MBA school some time ago, we didn't have the Adam Smith Society. The Manhattan Institute started it after I joined the Institute, and I was in law school a member of the Federalist Society, which is sort of the more free market-oriented, conservative, libertarian, textualist, originalist, whatever you want to call it, adjunct to the Adam Smith Society, and in some ways inspired us as we wanted to get out there and talk to MBA students. I know full well that when you're in MBA school, you're really learning crafts, you're learning skills that will carry you well as a professional, and you're basically trying to also get jobs and get job placements and things like this. But there's not a lot of opportunity to step back and talk about the bigger picture and the bigger questions. So hopefully I'll be able to do that a little bit today and tell you a little bit about my book. I would hope any of you might be interested, can pre-order this. If you want to order it through the Adam Smith Society, we can do that, and I can try to make sure you get a signed copy. So talk to your Adam Smith folks about that. And the basic premise of this book is that unelected actors, what I call the unaccountable elite, are governing America more and more and more. Things are quite different than sort of we learned them growing up in grade school. Most of you may still have grown up, maybe at least in the 90s. I don't think I'm quite dating myself enough to talk about things like Schoolhouse Rock that ABC put on Saturday mornings. And you had the old, one of the classic Schoolhouse Rocks episodes was, I'm just a bill. I'm just a bill. Yes, I'm only a bill. I'm sitting here on Capitol Hill. And that still describes how laws are made, but it doesn't describe how a lot of our legal rules are made so much anymore today. And we just saw that over the weekend, I suppose. I mean, Congress is trying to figure out how to handle the coronavirus, the COVID epidemic, to try to give relief to various people or state and local governments or businesses or what have you. And in the middle of negotiations, the president came out with one executive order and 3 executive memoranda, basically doing things or purporting to do things that are quite much normally thought of as legislative branch activities, including suspending taxes, not really cutting them, but suspending them, and allocating money, allocating funds, and cutting interest rates on loans that are owed to the federal government, et cetera. So this is quite a departure from that Schoolhouse Rock, I'm just a bill understanding. I want to emphasize this is not a partisan critique. We've seen this in prior administrations as well. In fact, Saturday Night Live opened with a cold open during the Obama years when he did unilaterally the deferred action for childhood arrivals, the so-called DACA and DAPA programs for immigrants, unauthorized immigrants here in the United States, and Congress wouldn't do what the president wanted. They couldn't come to agreement on a bill, and so the president did that unilaterally. Now, these are, of course, elected actors, elected presidents, and I think there are problems with elected presidents subsuming some of the legislative role. For one thing, it makes the presidential elections much more important and high stakes than they were in the beginning. But we really see a lot of this with unelected actors too. And we've seen that during this pandemic, which it's not unprecedented perhaps as a pandemic, but it's unprecedented in terms of the sort of government response we've seen to the pandemic, at least the size and scope of it. Yes, elected actors have done things here too. We had a $2 trillion appropriation, mind-boggling. The president invoking the Defense Production Act. Even the third branch, the judiciary, met for the first time ever virtually with basically a telephonic system, not a Zoom system like this for the Supreme Court, although many appellate courts and other courts have been doing that as well. So changed a lot of things, but I think we're all aware of just how significant some of these unelected actors in the government are. I mean, everyone now in the United States knows Dr. Anthony Fauci. He's been in his role for a long time, since the early 80s, and he is one of the most significant people in the government, albeit he's not somebody we ever vote on. But he runs the National Institute of Allergy and Infectious Diseases. He's won the Presidential Medal of Honor. But all of these sort of alphabet soup agencies, the Centers for Disease Control, the Food and Drug Administration, have been vitally important, and in some ways have helped, and in other ways have failed in our viral response. So at the outset of this crisis, on January 21st, we at the same time as the South Koreans were activating a test for the SARS-CoV-2. The genome had been identified, and on January 1st, we, as well as the WHO, activated this test. The FDA approved an emergency authorization for the CDC to do its test on February 4th. And then the FDA didn't approve any other tests until mid-March. So by that time, the government agency had only produced about 5,000 tests. And during the same period, South Korea had produced 5,000 tests per million over the same time. So that aggressive tracing in South Korea allowed them to cabin the virus in the early days, much more than the US. By the time the US allowed alternative testing, free market testing from businesses, state and local testing and what have you, it was the middle of March. Roche got the first authorization from the FDA on March 12th. And by that time, it was widespread really throughout the country, and it really limited our response going forward. I don't tell this story to heap too much blame on the unelected regulators here. I mean, they're facing a novel virus. Anyone could make a mistake, but I do want to emphasize the folks running this aren't hacks. They're not political actors. The head of the CDC is a virologist who has years of experience in dealing with viruses. One of the lead research people back in the day for HIV. The head of the FDA is an oncologist. He's got lots of virologists, epidemiologists, and what have you on staff. Ran MD Anderson in Houston, one of the biggest hospital complexes, has published hundreds of peer-reviewed articles. So these are scientists, these are doctors. But that doesn't mean they're necessarily going to be able to anticipate all the production and distribution requirements to mass produce a test across the United States very, very quickly, which is what was called for. And so we saw a lot of failure there, and it was an important failure. Again, I don't mean to suggest that we don't need these folks. I sleep better at night knowing that Dr. Fauci is there and knowing that he's on call. I mean, our military's made hosts of mistakes over the years. We still need them, and we still depend on their expertise. But the point here is that this is a very, very different sort of government than we had at the American founding at the outset. In 1787, when the founders left Independence Hall, a passerby, this may or may not be apocryphal, but it's regularly attributed, to Benjamin Franklin. Someone said, "What kind of government did you create?" And leaving the Constitutional Convention, Franklin said, "A republic, if you can keep it." And I want to emphasize the design that those founders came up with, while certainly flawed, and we'll talk about some of those obvious flaws in a minute, but it's been remarkably adaptable, remarkably durable. The government has survived invasion, it's survived civil war, foreign conflict. It's been through national expansions and social transformations, economic depressions, obviously pandemics, including this one, and it will survive. At the first national census, we had only 4 million enumerated individuals in the census. We've grown almost 2 full orders of magnitude since then. In the original United States, there were only 5 cities that had more than 10,000 people in the original census. New York City, the largest municipality in the original census, Philadelphia was the largest metro area. New York City had only 33,000 people, the biggest city in the United States. And over the intervening centuries, we've become urbanized, we've become suburbanized, we've modernized. We've gone from 13 states to 50. We've had the strongest military the world's ever seen, the largest economy the world's ever seen. Of course, there were flaws in this original conception as well. And I want to emphasize, I'm not looking back to the past with shades over my eyes on that. All but Massachusetts, all the original states permitted slavery at the time of the Constitutional Convention, and the Congress basically punted the question. It would be decades more before we ended the institution of slavery, and more than a century before we got rid of express discrimination on the basis of race and sex, and before we extended the franchise much more broadly to adults in this country. So in many ways, we have improved on the original constitutional design, but we've also lost something. I mean, our government today has grown even more than the population, substantially more. So the first Congress had a budget of $639,000. Now, we've had inflation since then, but if you adjust for inflation, that's about $10 million in today's dollars. And we're coming off a budget, an unprecedented budget of $4.4 trillion. And that's before we have these extraordinary expenses this year in response to the pandemic that will blow that record out of the water. So we've grown more orders of magnitude significantly in terms of the size of government and what government does than we have in terms of just population. But beyond that, what I think we've lost, beyond the size of the government, a lot of people have written about that, we've also lost some of our conception of self-government. So the original conception was one of self-government, publicly accountable government, as well as bounded government, limited government in scope. And what we've come to with individuals like Dr. Fauci, but not limited to Dr. Fauci, we're talking about millions of people working in the federal government, millions of private attorneys litigating in court, tens of thousands of municipal governments, all the 50 state governments, et cetera, a much larger government, but also a less accountable one. I mean, again, we are more accountable in the sense that the franchise has been expanded, but the actual decision-making structure is much more carried on today by unelected actors than it was at the time of the founding. And I really, in my book, sort of talk about 4 different types of this. So one is rulemaking, the rule makers. And this is what we think of when we talk about the administrative state, administrative agencies that are making rules. And by and large, the Congress is punting these rules to the agencies to craft. So the Congress will set up broad principles, the agencies will draft the specific rules. Any of us could get entangled in these rules. In fact, there's an estimated 300,000 federal crimes on the books. 98% of them were never voted on by Congress. So when they were enacted, they were created through rulemaking and regulatory processes by administrative agencies, never going back for a congressional vote. Second, we've got the enforcers. And the point is here, without a formal rule, the government still can scare the bejesus out of you. If they can take your money, or if they can put you in prison or destroy your business or your enterprise, the government has a lot of authority. And so we see a lot of what I call regulation through prosecution, or the threat of prosecution, or the threat of enforcement. And this often can be more important even than the formal rulemaking itself. And we've seen a trend towards rule by guidance letters and guidance documents, and really the threats of prosecution without actually prosecuting itself. So trillions of dollars a year in what I call deferred prosecution agreements are reached with big businesses. 1 in 6 of the Fortune 100 companies over the last few years have been operating under the thumb of the federal government, the Justice Department, through these deferred prosecution agreements. Third, we've got our litigation system, the litigators, and this is something that is idiosyncratic to the United States. Not that there aren't litigation systems in all the other developed countries, there are. But ours is 3 times as expensive as the European average as a percentage of our economy. And we have a much more decentralized system. We're rather unique in having jury trials for complex civil matters. And we certainly are unique in allowing what we call notice pleading with open-ended discovery and aggregated claims, and the sorts of things in our legal system that allow for the sort of litigation lottery or shakedown lawsuits that also exert substantial regulatory power over the broader economy. And then finally, we have what I call the new Anti-Federalist. So if we're talking about the federal structure and talking about how we've departed from that, it's important to understand that in the original conception, the Articles of Confederation weren't quite working right, and one state was doing things to impede commerce in the other state. And so while our federalist system is a virtue overall, it decentralizes power, it allows people to move, it allows capital to move, so that if a state is overtaxing or if it's providing inadequate services, people and businesses can relocate. And that's a powerful pressure on government to try to get it right. But also some state actors, including private litigators, but also especially state attorneys general and the like, can utilize their state, what we call police power, their regulatory authority, and dictate the terms of national commerce. And we've seen that more and more. Now, properly, these tend to be elected actors. A state AG tends to be elected. But they're not elected by the national populace. So nobody in Oklahoma or Alabama or Alaska has voted for the Attorney General of California, and nobody in Fargo or in Denver or in Amarillo has voted for the mayor of New York City or what have you. So these are I think, important trends for us to keep in mind as part of the overall regulatory package. I've got a lot of stories in this book. It's a personal book. They're personal stories of people and businesses that have gotten ensnared with this regulatory state, and I've got some policy solutions as well. But anyway, this is the broad sketch of what I'm talking about here. I want to cut this off and not ramble on too long myself, and open up to some questions, or maybe Greg will have some questions to start with, and then we'll open up to the audience.
Thank you very much, Jim. And at this time, I would like to invite audience questions. Please state your name and your chapter affiliation to submit your question. And so, yes, Jim, let's kick things off. Thank you very much, Jim, again, for that synopsis of this very important issue. I'd like to ask the question, just to kick things off, well, isn't some form of administrative state necessary, inevitable? Can Congress really vote on things and write the legislation for every conceivable rule in our modern society?
The basic answer there is yes. The administrative state is necessary in some form or fashion, and we've had some form of it since the earliest days of the Republic. I do think that the question of who decides matters, though. And in the early Republic, there were debates on this in the very first Congress when they were developing the postal roads. What were the paths of the roads? Where were the post offices going to be? And some folks in the Congress said, just let the president and his staff, the postmaster general, figure this out. And others objected, including James Madison, who was the principal drafter of the Bill of Rights and much of the Constitution in the drafting committee. And Madison said in the House, no, we better not delegate that. We have so there's been a long principle of what we call the non-delegation doctrine. And as the court started teasing this apart over the decades, basically there were two principles. So if what we're talking about is filling in the details, filling in the gaps in the statutory scheme, delegation can make sense. I mean, in other words, the level of detail isn't as important for Congress actually to vote on. I mean, obviously, the bigger your government gets, the more impossible it is for Congress to vote on these things. That said, the level of detail, the fact that the level of detail may be decided upon by administrative agencies doesn't mean you can't come back to Congress, right? I mean, we do this, for instance, in trade law. Congress has the power to set tariffs, and since the 1930s, they've delegated that power to the executive to negotiate, because in modern commerce, rather than just setting tariffs, often we negotiate and try to get other countries to respect intellectual property rights or to lower their tariffs as well, or non-trade barriers, et cetera. It becomes complicated. And so they give this trade negotiating authority off to the executive branch, but then it has to come back to Congress for a vote, right? So I think it's significant that 98% of the federal crimes, hundreds of thousands of them, more than we could ever be on notice for, are created without Congress ever voting on the substance of those crimes. And so one of the ideas I put forth in chapter 14 of the book, and that some of my Manhattan Institute colleagues and I have developed over the years, is saying, well, if there's a criminal penalty, let's at least force Congress to vote. And so there are various mechanisms you could put in place with that. The other issue here is one of what the decision-making scope entails. So in the early cases, if it was just filling in statutory gaps, or if the executive is making a yes-no decision, and the classic yes-no decision is the decision to prosecute, what's called prosecutorial discretion. So Congress says murder across state lines is a federal crime, it's illegal. The executive still has to decide whether to bring a prosecution, right? So there's inevitably some discretion in enforcing the law, and Congress can do that. But what they couldn't do until the last 80, 90 years or so was give the overall question about what the crime is over to the executive branch. And the Supreme Court's been clawing back at this a little bit through what they call the major questions doctrine. And so in the last few decades, when the executive branch has tried to regulate cigarettes, notwithstanding substantial legislation in Congress that did not put cigarettes under the FDA, they said, well, you can't do that. Similarly with greenhouse gases, what they've said is if it's what we call a major question, we want Congress to say something. We don't want Congress to pass sort of an open-ended law or a vague law or a law that was intended for a completely different purpose, and then have the executive branch totally reverse course without going back through Congress. So the courts have done a little bit to rein this in, but there still tends to be a vast amount of delegation in rulemaking authority. And so, yes, we need an administrative state both to enforce, but also perhaps to craft some of these rules. But there's no reason why Congress shouldn't have the authority to review these rules before they have real teeth, or perhaps we could sunset them, or perhaps we could put them through cost-benefit analyses and what have you. There's various ideas that I float in the chapter 14 of the book.
Mm-hmm. And so in follow-up to that question, Jim, one of our professional members, Mark, asks, what do you say to the argument that the economy is so complex, so laws need to be complex, and to what extent does that justify the existence of these administrative agencies that are, I guess, trying to fill the roles that Congress just can't?
Yeah, I mean, I think there's some truth to that. You can argue it both ways. I mean, my colleague Richard Epstein, longtime at University of Chicago, now at NYU, and a visiting scholar at Manhattan Institute, wrote a book called Simple Rules for a Complex World, saying that sometimes the simple rules make more sense for a complex world. But I do think that having some bright line rules and some clarity, safe harbors and the like for businesses is better in many cases than some what we call an ex post review regime through, say, our litigation system, particularly if the litigation system involves adversaries and lay juries and loose evidentiary rules where you can basically entrust the design of automobiles or pharmaceuticals to a lay jury of 12 relying on competing expert witnesses for hire. I mean, I do think that there is a case for some of that administrative regulatory state. I do want to emphasize, though, that making this too broad reaching or too punitive as an ex ante complex regulatory regime necessarily punishes small entrepreneurs, necessarily punishes family farmers, necessarily punishes those who don't have teams of lawyers, and puts pressure towards large business enterprises, economies of scale. Yes, if you guys go work for ExxonMobil or for Google, they have teams of lawyers to navigate this thicket. But if you want to start your own business, it's going to be much harder to do so. Even if you hire a smart lawyer or two, without having a big, experienced in-house compliance team, you could run afoul of the law quite quickly, and it could end up upending your business model quite quickly. And so I think it's important to realize that complexity can cut in both directions. What I do think complexity does do is mean that there's not going to be a lot of social appetite for the old school law. In contract law, it's called caveat emptor, let the buyer beware. But I want to emphasize that even there, we can overplay it. I mean, yes, we want to have some sort of warranty. We want to have maybe a pre-review process. We may want to have an ex post liability system. But do we really need lay juries and a litigation system or a regulatory system to regulate the temperature at which McDonald's serves coffee? And I use this example because it's a well-known one. There was a Seinfeld episode spoofing it, Stella Liebeck's hot coffee spill in the 1990s. And yes, she suffered serious burns. This was a woman in her 80s. It was served to her relative in the car. She spilled it on her lap and had a type of fabric that absorbed and clung. It stayed close to her skin for some period of time, and she suffered severe burns from this. But do we really want lay juries trying to tell McDonald's? I mean, McDonald's has billions and billions served. I mean, that used to be their motto for decades, and that means billions and billions of coffee cups served. If there's if the local people at McDonald's weren't following the McDonald's protocols or things like that, I mean, I don't mean to suggest there would never be a case. And McDonald's had settled some of these cases before, but they had always settled the cases only when they had a person spill it. In other words, the person working the counter accidentally spilled a cup of coffee on the customer. They settled those cases. They didn't settle it where they handed it off and the customer spilled an obviously hot beverage on themselves. So I do think that when we have an iterated market in place for relatively simple questions, the market can work better than we think. If McDonald's coffee is unreasonably hot, people won't buy it. Similarly, when it comes even to complex products, I mean, I'm buying I just bought a webcam for this. I mean, I bought a computer within the last year. I bought a big HD TV within the last year. I bought a new automobile within the last year. I don't understand how any of this works. But the market works pretty well there. And then there are, especially in our the complexity of the modern world enables us to get consumer reports and various reviews, et cetera. And we can get market feedback in so many ways on complex products. That doesn't mean we don't need any regulatory structure. You can have products that seem safe and effective, like asbestos, and then years later, decades later, you find out, wow, this is really dangerous, and we need to do something about it, and we don't need this on the market, or the costs outweigh the benefits, et cetera. So there's a case for a regulatory regime. But again, I think the complexity doesn't necessarily require the regulation, and I certainly don't think the complexity requires Congress to punt the hard questions. That's the real question. Should Congress have to compromise, or should Congress at least have to say, okay, you regulators came up with this regime, we're going to enact that into law, rather than we're going to pass a broad, principles bill and let the executive branch, unaccountable bureaucrats, draft this, and we're not even going to give that to the president. We're going to give it to a so-called independent agency that the president can't even fire the members of, and they have staggered terms, et cetera. So we have this double layer insulation of rulemaking, and Congress could, of course, come in and change all that through a new law. They retain that power, but what we've seen is time and time again Congress punting that, and whether that's through executive order or through independent agencies or through guidance letters or the threat of prosecution, any of these sorts of mechanisms that the government's using, it's something far removed from the sort of elected Congress that was designed to have various checks and balances. So one reason we have big government and bigger government than we might like is the fact that we've found in-runs around those checks and balances. Obviously, that's going to mean some of our progressive friends may prefer this sort of delegation system relative to those of us who prefer a smaller or more limited government model in the first place. But I do think we hopefully should be able to agree that something's lost by having all these unaccountable actors making decisions that really have such sweeping import for all of us. All we have to do is imagine, well, what if the other side won? What if the other side got their way on this question with these unelected, unaccountable actors?
Right. And so I'd like to explore this idea of yours of the new anti-federalism. And so how do we distinguish between proper federalism and anti-federalism?
Well, as I often do here, I want to distinguish in answering that question between the law and the policy. And I'm a legal policy scholar, so I care about both. But when it comes to the law, sometimes we follow the law even if we think it's wrong, right? So the original constitutional design may get some things wrong, but unless we change that constitutional design or change the legal structures, change the regime, we ought to follow that law, even if it leads to policy outcomes we don't like. I mean, that's sort of the basic rule of law principle, I believe. And if we try to amend this by ignoring it or having the courts not do their job, et cetera, there can be second order effects down the line that we don't like. So stepping away from that for a moment, I do think that the original constitutional structure gets it largely right on these questions, particularly as amended, where we put in the post-Civil War amendments that put some limits on the state governments and have kept the state governments from being quite as abusive as they could have been in the earlier years of the Republic. But given that, I mean, I think the real questions here is one that those of you're in business school, so you've heard some of these sorts of concepts before, but I think about it as, are the costs internalized, and are people and capital able to move in a way that's consistent with those costs being internalized? And so let's think about it from, say, the litigation system, for instance. If you're talking about lawsuits that involve a slip and fall, you're in Walmart, there's a wet floor, you slip, you trip, you're injured. That sort of legal regime is largely going to be internalized to the state. So if the state has a bad legal regime, and that could be the substantive or the procedural law of the state, you're basically going to pay the cost of that within your state. It's going to be harder to run a business, harder to employ people. It's going to be more expensive to sell things in a store if you allow people to recover unreasonable amounts from a slip and fall. Now, of course, even there's a limiting principle. If you allow the lawsuit to be so large that it could knock Walmart out of business, obviously you could hurt other states as well. And in fact, there was a lawsuit that approached that in the 1990s, BMW v. Gore in Alabama, where a undisclosed scratch that had been painted over and repaired by a car company prior to the sale, which was a couple $1,000s of potential liability, led to a multi-million-dollar verdict in the Alabama courts that the state Supreme Court upheld, and the U.S. Supreme Court said no. Whether the legal rationale was right or not, and it's one subject to significant debate. I don't know if it will endure, but they basically said no, this is a due process violation, because if it's not, if it's 10 times, if you sort of have a multiple or treble damages, because you assume not everyone's going to bother to take these lawsuits, that's fine. We can allow that, but we're not going to allow a multi-million-dollar suit over a scratch, right? Mm-hmm. So even there, you can run into a limiting principle. You can sort of have these intermediate cases. I mean, medical malpractice is another one where the Federalist pressures tend to work, right? I mean, if a state has a loose med mal regime, it tends to affect the availability of of doctors in certain specialties, at least in certain areas. It tends to affect the cost of healthcare, at least on the margins. And so states have some incentive to get this right. And of course, doctors will also lobby, as well as consumer groups opposite the trial lawyers, on some of those sorts of questions. Of course, there is a federal cost as well through Medicare and things like that when we have a large sort of entitlement scheme. And when you come to something like product liability, it becomes very different, because typically products in our national commercial space, at least products like pharmaceuticals that engender lots of lawsuits, are manufactured in one place and sold somewhere else. And under the legal regime we've got, there's no way for a producer to say, we're going to move all of our factories to Wyoming because they've got the best legal regime to protect us. Well, you're still going to be sued if you sell it anywhere outside Wyoming. So all the other 49 states have a regime there. And at the extreme of that, back when you could have class actions at the state level that governed national commerce, we saw some very perverse effects. And this was one of my earliest things I worked on at the Manhattan Institute, was what we called magnet class action courts, where a few counties were attracting the bulk of major national class action litigation and effectively deciding these questions through class action lawsuits for the rest of the country. And so Madison County, Illinois, East St. Louis, on the Illinois side of the St. Louis line, kept getting case after case after case. And in some cases, the Illinois courts were overriding other states' express provisions of law and regulation. So for instance, if you have a auto insurance policy and you get into a car accident, the question is, what kind of repairs do you get? And does the insurance company pay for so-called OEM parts, or official equipment manufacturer, or something like original equipment manufacturer parts? Anyway, OEM parts are made by the company. So if you wreck your Honda, you get the part made by Honda, or can they use a generic part as a substitute? And there are pros and cons to this. The generics tend to be cheaper. You also can get junk. I had a auto accident in New Jersey, and the auto dealer and the insurer, they ended up using junkyard parts, and I ended up having to get all the work redone. So there are pros and cons to this. But the Illinois courts decided, through a class action lawsuit that was on behalf of a national class, to say, well, no, you can only use OEM parts. And that's to protect the consumer. Well, the problem with that is, of course, they cost more. And you had other states, including Massachusetts, that had on the books laws and regulations that said you have to use generic parts, because they were trying to keep auto insurance rates down. And so effectively, Illinois' tort regime was overriding the express legislative choice of the Commonwealth of Massachusetts. Now those sorts of lawsuits can be removable to federal court based on a 2005 law that was based in part upon our empirical research at the Manhattan Institute, the Class Action Fairness Act of 2005. But in lots of other non-class action contexts, mass torts for pharmaceuticals, and various product liability suits, you still see these same things in play. So this is sort of what basically what I want to say is, are the costs internalized, and are you stretching beyond your borders? So it's one thing for the Attorney General of New York to try to regulate New York businesses. It's another thing for the Attorney General of New York to try to regulate the entire national marketplace of businesses. And it becomes tricky. There's not a clear either or. In other words, I would be a critic of what the New York AG just announced in terms of the NRA suit, at least in terms of the remedy, which is to dissolve the entity. And I think it's probably not a viewpoint neutral lawsuit and is targeting the group based on political considerations or viewpoint considerations. But if it's a New York chartered nonprofit, I mean, the AG is supposed to look after the New York chartered nonprofit. And so the New York AG is going to have disproportionate power with the financial insurance industries, et cetera, disproportionately within the state. But there are other instances, things like climate change, et cetera, where you've got localities trying to affect the national response to climate change based on various alleged legal theories and et cetera. So there's not a clear, bright dividing line here. But I think there are certain principles, and there are cases in which where we have a national regulatory regime, what we don't want is the worst of both worlds. Sure. So we don't want a world where the FDA is heavily regulating the label on your pharmaceutical product, and then you can get sued for the label on your pharmaceutical product when someone gets injured, when the FDA has done the cost-benefit analysis and decided, well, notwithstanding that risk, we want the product on the market. But that's right. In fact the case what we have right now.
Right. Okay, great. And so, Jim, in the few minutes we've got left here, I do want to get to two last member questions here. We've just got a couple minutes, so we'll do like a 2-minute lightning round here if we can. First question from Max in our New York City professional chapter. Again, I think this has to do with how much control does this administrative state have vis-a-vis the president. So his question is, how real is the so-called deep state? And if it is real, how much executive branch power does it hold relative to the president? So that's question number one. Question number two, and maybe this is a good way to sum up, question from Philip in our Chicago Booth chapter. It really asks about what reforms do you propose? He asks, can you expand on the policy proposals you alluded to and where you are more optimistic that these could be successful and where less so? So in just a few minutes left, those two questions.
Yeah, I mean, I think the deep state, it's got a political resonance, but I think the deep state is a real phenomenon. I mean, part of what happened in the late 19th century is we came up with civil service reforms to try to prevent the politicization of the executive branch and really the longstanding sort of tradition of putting your political allies in palm political jobs where they could sort of profit off the government and try to have a more professionalized executive branch. I think there's a lot of strengths to that. But I also think that it does create sort of a long-term inability for a single administration to reverse course in some respects because the administrative branch can resist the elected president. Now, the elected president does have a lot of power, and it really depends on what part we're talking about of the government. If it's an independent agency with a bipartisan board that's staggered, the president has a lot less power over that area at which the Supreme Court has permitted than over something where the head of the agency reports to the president. If the head of the agency reports to the president can fire without cause the head of the agency, the president has more power. And so it really depends what we're talking about. And sort of on the one extreme, we've got something like the Federal Reserve Board where the budget can't even be touched and it's quite independent. On the other extreme, we've got something like the Office of the White House Counsel, but also, even something like the Department of Justice, as we've seen, the president can fire there, although there can be firewalls put in, independent counsels, et cetera, in certain cases. When it comes to policy proposals, I mean, there's no easy solution here, but I think the Supreme Court's going to probably put more firewalls on some of the administrative state stuff. I think Congress needs to act. It's easier said than done. I mean, if you've got a bipartisan split in the Congress, it's hard to get things enacted. I hope they'll pay more attention to some of these processed questions going forward, because I do think that they matter in the long term. There's a tendency when your side's in power to look the other way. And so we've even seen this just over the weekend. The Republicans seem to say, oh yeah, they're with a few exceptions, Ben Sasse, who's now getting tweeted at by the president, with a few exceptions, most of the Republicans are saying, okay, we're supporting Trump's executive orders, and most Democrats are, they're not necessarily crying foul because they realize in the long run they want to be able to do the same sort of thing, but they're more arguing on the substance. And so we do see this sort of flip-flop depending on which party's in power. I think that's a long-term mistake. I mean, you have put this in question, just to put this in perspective. The first year President Trump was in office with a deregulatory agenda, the executive branch added more than 61,000 pages to the Federal Register. And what's remarkable about that is that was actually the lowest number of new pages added to the Federal Register by the executive branch since 1993. The final year of the Obama administration, they'd added more than 95,000 pages to the Federal Register. So when things are this mammoth and this complex, it's hard to sort of turn that ship. And so I think putting in some of these firewalls, forcing Congress to act and review things, putting in express review provisions, putting in limitations on the ability for guidance documents or prosecutorial agreements to reach regulatory ends, and we only barely touched on the outside of that, and then putting in firewalls to prevent this sort of race to the bottom through either state action directly or through the litigation system, I think can go a long way.
Well, Jim, we're going to conclude there. Thank you so much for joining us today. That was a really interesting conversation. Again, I encourage everyone to check out Jim's forthcoming book, available for pre-order now, The Unelected. Please check it out. It's available widely online. So, Jim, thanks so much. Really a lot to think about in terms of how do we balance the needs for regulation with the needs for free, open, competitive marketplace, both in terms of how states compete for people and businesses and how businesses get started and compete among other businesses. So, Jim, thanks so much. We look forward to seeing everyone again soon for our next Eventcast. I wish everyone an enjoyable rest of their summer. Thanks so much for joining us.
Thanks for having me.